We just have 3 sessions. The Skype with Ambassador David Scheffer, 20 minutes. And then the discussion on essentially what needs to be done. And then the closing keynote by Professor Gayatri Spivak. So I'm just trying to get David on Skype. Oh, he's here. Okay. David, yes. Can you hear me?
Yes.
Okay. Will you please be seated? We are just about to start in 10 seconds. Okay. The bio of Ambassador David Scheffer is in the booklet, so I won't read through it. Just except to say that Ambassador David Scheffer has been a passionate believer in the international justice system, however flawed it is. Some of us may agree, and I had disagreed with him about a month ago at the Oxford Union panel, but he still comes with an extremely valuable insight on the different scenarios of justice, because this also relates to what Professor Gayatri Spivak will be talking about. The focus on the law, but let's also think about justice. And so, David, without further ado, the floor is yours.
Thank you very much, Zarni. And can you confirm to me that you can hear me properly?
Yes, we can hear you loud and clear. Yeah.
Good. Okay, fine. Well, first of all, I want to thank everyone for attending the conference, and I am deeply honored to have been invited to join you in the conference and to offer my humble thoughts about the very disastrous situation that has confronted the Rohingya, and I want to try to make whatever contribution I can to the discussion. I have several points to make, and I'll make them, one after another, and then perhaps we'll have a few minutes of time left for questions to be posed to me. I'm sorry I'm not with you in Berlin, but I've got teaching duties here at the law school that require me to be in Chicago. I want to start out by sending sort of a clarion message to everyone, and that includes the leadership in Myanmar. It is a fact that the age of impunity is over. One cannot, in any relaxed state of mind, commit atrocity crimes, particularly against one's own people, not to mention those on other lands, and assume that you can do so with impunity, that there is no prospect of bringing you to justice. That was the situation about 25 years ago, absolutely. It is no longer the case. Now, that doesn't mean that, leaders will, it does mean that leaders will get away with it. Some of them will not actually be brought to justice. But their sort of bubble of security is getting tighter and tighter with respect to whether or not they can avoid justice. There are many, many instruments of law now that can be used, at a minimum, to indict them, and at a maximum, to bring them to trial and judge their guilt or innocence. So I think it's just important to frame the whole context of this discussion not as one of futility about bringing anyone to justice, but rather one of the certainty that there can be no relaxed attitude about impunity by those who commit atrocity crimes, be it genocide, crimes against humanity, war crimes, or aggression. So that's point number one. The second is having had a considerable amount of experience myself in Southeast Asia throughout my career, I would want to put down the marker that the often heard call of Southeast Asian and ASEAN nations of non-interference in the domestic affairs of their neighbor states in ASEAN has become a rather irrelevant point, particularly when it comes to the Rohingya. It cannot possibly be the argument of any ASEAN government, and particularly of the government in Myanmar, that they have a right under the UN Charter to non-interference in their domestic affairs when the thrusting of almost 1 million Rohingya across the border in Bangladesh is intensively disruptive to the domestic affairs of Bangladesh. It would be a hypocritical, contradictory, and frankly incomprehensible argument to make. So in other words, we can take that argument off the table that somehow any attention to what is happening to the Rohingya within the borders of Myanmar, as well as, of course, in Bangladesh, somehow is interfering in the domestic affairs of a member state of the United Nations. I would take that argument completely off the table. Third, what I would like to do is explore some judicial options, which come to me from many decades of experience in doing so in other parts of the world. So I want to walk through these with you as efficiently as I can. And of course, each one could elaborate into much longer discussion, but we don't have time for that. So I'm just going to go through this like a checklist. The first, of course, is justice for the Rohingya against the military and even political leadership of Myanmar, of course, could be pursued before the national courts of Myanmar if that were a possibility. Obviously, the jurisdiction would reside there without question. We know as a fact, however, that it is improbable in the short term that the national courts would be available whatsoever for this. It could be that 15, 20 years from now, under a refreshed sense of democracy in Myanmar, that the national courts could be activated. And that's why the collection of evidence is so very important at this stage. Preserving that evidence and the chain of custody of that evidence is extremely important, because international justice is the long game. It's not the short game, it's the long game. And it could very well be the case that 10, 15, 20 years from now, trials could take place in Myanmar using that evidence. So national courts, of course, are obvious forms, but we know at this point they cannot be accessed. Secondly, the International Court of Justice in The Hague, the United Nations top court. It is a fact that Myanmar and Bangladesh are parties to the Genocide Convention. Now, under Article 9, I believe it is, Article 9 of the Genocide Convention, that's the dispute clause. Any dispute regarding the Genocide Convention has to go to the International Court of Justice if it's not resolved otherwise. So it is entirely possible that Bangladesh and Myanmar could be brought before the International Court of Justice. You would have to presumably persuade Bangladesh to initiate that action. But it is a possibility that the issue of whether or not the government of Myanmar has been engaged in acts of genocide with the intent to commit genocide against the Rohingya, that issue could be brought before the International Court of Justice. And in the consideration of such a case, there could also be consideration of whether or not there are parties that have been complicit in the commission of the genocide, because that's part of the Genocide Convention, and there could be a dispute between Bangladesh and Myanmar as to whether any governments that are supporting the military of Myanmar with military equipment, etc., and sort of turning a blind eye to what's going on with the Rohingya, in fact, are complicit in the military's assault on the Rohingya population. So I just put that down as a second possibility, that it's not beyond the pale for the International Court of Justice to be activated, but it would require, at least on the surface, Bangladesh's cooperation. Theoretically, you could have another state to the convention apply to the ICJ, but of course the strongest case would be if Bangladesh did. The third possibility is universal jurisdiction exercised by a foreign court, foreign national court. Now, I won't go into all the details about universal jurisdiction other than to say that in recent years, governments that have initially launched into statutes with broad universal jurisdiction for their courts with respect to atrocity crimes have scaled back that jurisdiction with conditionality, usually nexus requirements, whereby the government would look to see what is the connection between our people and our government and our territory with the commission of the atrocity crimes that are taking place in Myanmar. But that's not impossible. That can be a link through victims, through citizens who have been subjected to this violence in Myanmar, along with the Rohingya, alongside. In fact, if you've got two journalists, foreign journalists who are now being held, that's also a factor of possible linkage of jurisdiction. And so there are options that one could play with on the universal jurisdiction front. It's highly problematic, very risky, but it is out there as a possibility. Fourth would be a hybrid court. Now, we have built many hybrid courts over the last 25 years. The Special Court for Sierra Leone, the Extraordinary Chambers in the Courts of Cambodia, the Special Tribunal for Lebanon, the Kosovo Specialist Chambers, the East Timor courts. These are all hybrid. They all are created with somewhat different formulas. No two courts are exactly the same in terms of how they were created or their statutes were devised. But if one thinks about it in the context of Myanmar and of Bangladesh, you could look at the possibility of Bangladesh, if it had the political will to do so, entering into a treaty with the UN General Assembly, which is exactly what we did with Cambodia, exactly what we did with Sierra Leone, exactly what we did with Lebanon, in order to create a hybrid court that is essentially a joint venture with the United Nations. It doesn't require the Security Council. It's a General Assembly action. And that treaty relationship between the International Organization of the United Nations and a national government such as Bangladesh can set up a hybrid tribunal with its own statute and rules of procedure and evidence, et cetera, in order to deal with a set of atrocity crimes. Now, typically, in the past, these have been crimes committed on the territory of the national government that enters into the treaty with the UN General Assembly. And that was certainly true with Sierra Leone, with Cambodia, and with Lebanon. But as you will see in my next argument, Bangladesh has a very good basis for arguing that, yes, this very much affects them on their territory, and that they need to exercise jurisdiction with respect to these crimes through what would essentially be an international criminal court established by treaty with the General Assembly. Remember that the Special Court for Sierra Leone and the Special Tribunal for Lebanon are legally defined as international criminal courts, not domestic courts. The Cambodia Tribunal is a domestic court, but it has entered into a treaty arrangement of cooperation and assistance with the United Nations. So you can go either way, depending on what direction Bangladesh would want to go. But once that tribunal is set up, its statute can literally dictate that the jurisdiction of the tribunal includes the crimes in Myanmar to the extent that those crimes have an impact upon Bangladesh territory. This is somewhat similar to the Special Court for Sierra Leone, where Charles Taylor was the president of Liberia, and yet he was captured by the jurisdiction of the Special Court for Sierra Leone because Charles Taylor strategized the assault on the civilian population of Sierra Leone from Liberian territory. So the court literally captured him in its jurisdictional reach and successfully prosecuted him, and he's living happily ever after in a prison in the United Kingdom. So that is a possibility. And I just point you to Article 8 of the Genocide Convention, where it says that states parties can call upon competent organs of the UN, that includes the General Assembly, to undertake measures with respect to genocide. And of course, one of them could be a treaty to create a hybrid court. So let me move to the fifth option. And the fifth one involves the International Criminal Court, which is probably the one that most obviously comes to people's minds. The easiest way to activate the International Criminal Court, as you all know, would be to have a referral under Article 13b of the Rome Statute and Chapter 7 of the UN Charter, a referral by the Security Council to the ICC to take up Myanmar, which is a non-party state, but under Security Council power, that can be referred to the ICC, and the ICC then has full jurisdiction. The problem there, of course, is blockage by Russia and China. I think it would be possible to negotiate a unified stance by France, United Kingdom, and the United States as permanent members. The question is how to get Russia and China to abstain and not veto it. What I would initially explore there and place some pressure on is whether or not governments are, key governments, such as those three permanent members, are putting enough diplomatic pressure on Russia and China to have an abstention on the issue of international justice for the Rohingya. And if they're unwilling to refer the situation to the ICC, then call them out on it. Just make them accountable in the public eye for failing to achieve justice for the Rohingya. Put that on the public record. Now, if a referral by the Security Council is not possible, there are three other ways to get it in front of the International Criminal Court. And all three ways depend upon an argument for jurisdiction that would be unconventional, but exceptionally pragmatic. And therefore, I think would gain some traction in the thinking of the judges at the ICC. When you look at the crime scene, of course, is Myanmar. That's where the ethnic cleansing is taking place. All of the atrocity crimes are literally occurring on Myanmar territory. Myanmar is not a state party to the International Criminal Court. So when you look at this sort of from a conventional point of view, the nationals the perpetrators are not nationals of a state party, and are being committed on the territory of a non-party. So ergo, the ICC has no jurisdiction without a Security Council referral. However, what is the crime scene? I mean, let's be very pragmatic about this. The crime scene does not stop at the border between Myanmar and Bangladesh. The crime scene very purposely and intentionally on the part of the Myanmar military flows over into Bangladesh in a massive way. When you're talking about ethnic cleansing, just ethnic cleansing itself, the whole purpose of ethnic cleansing is to remove a population from a sector of territory so that it's no longer living there. Now, we know that the Myanmar military has not conducted ethnic cleansing for the purpose of moving the Rohingya to some other part of Myanmar. Their intention has been to displace the Rohingya onto Bangladesh territory through ethnic cleansing. That has been their intent, their purpose, their tactics, their strategy. I say that sort of boldly without, obviously you've got to show all the evidence for that, but I mean, it appears rather self-evident from what is occurring there since August. And so I would argue that Bangladesh, which is a state party to the International Criminal Court, is experiencing the commission of crimes on its territory through the consequences of ethnic cleansing, through the impact that mass rape has when you're thrusting this population across the border, a large number of them women and children. To argue that the crime scene stops at the river's edge between Myanmar and Bangladesh, when it is the intention of the ethnic cleansing in this case to move these people over the border into Bangladesh, I think that argument has to be a self-evident argument. Let me just show one comparison. In Bosnia, in the early 1990s, you bet there was ethnic cleansing. It was massive. But were Bosniaks being intentionally driven out of Bosnia by the Bosnian Serbs? Well, yes, there was a large refugee flow, but I think when you look at the issue of intent, it was more the intent of the Bosnian Serbs to corral the Bosniaks in other parts of Bosnia. This is a very, very different situation of ethnic cleansing. So how could you then get this to the International Criminal Court? Well, there could be three ways if you argue this case. One would be a self-referral by Bangladesh itself. It would have to have the political will to do so, of course. But all of the state referrals so far have been self-referrals. And so that's not unusual. But Bangladesh would have to have the political will to self-refer the issue to the International Criminal Court. And of course, take its chances with respect to whether or not the judges would endorse this view of the crime scene. Secondly, any state party to the Rome Statute could refer this situation to the ICC. Again, you're resting your hopes in the judges buying the argument. Nonetheless, it would create enormously high profile to the whole issue. Now that means that, Peru tomorrow could refer this situation to the ICC. Literally, it could. It has nothing to do with it. Peru has absolutely nothing to do with what's going on in South Asia and Southeast Asia, but it has the right under the Rome Statute to refer the situation. So diplomatically, the challenge would be, can those parties with concern about the Rohingya, and even Bangladesh, can a government that is a state party to the ICC be persuaded to make such a state referral? It's perfectly entitled to do so. And then third way of doing this would be the prosecutor herself, Fatou Bensouda, who could, under her proprio motu, or independent prosecutor powers, investigate this, make the argument of the crime scene, and then put it up before the pretrial chamber of judges and ask them either to endorse the argument or not. It would be a risk. She might risk losing it, and of course, I have not presented this argument to the prosecutor, and she may consider it too unconventional. But my point is that she also is a pathway that could be activated. Now, let me just go back. I'm going to finish up very shortly, Zarni. Let me go back for a moment to the Rome Statute itself, just to nail this down. The territorial jurisdiction of the Rome Statute, it has some very interesting wording in it that we negotiated. It says, there will be jurisdiction if the state on the territory of which the conduct in question occurred. Now, that doesn't say where the crime was committed. It says the conduct in question occurred. So my reading of that would embrace the possibility that where a crime scene is so extensive that it reaches over a national border into the territory of a state party, that Article 12.2 is so constructed as to embrace that possibility. Let me just throw in, under US law, federal law, we have something in tort law called the Calder test, C-A-L-D-E-R test. It was confirmed by the Supreme Court here in 1984. And it basically says as follows: where a defendant engages in behavior designed to inflict harm in another jurisdiction, he is subject to jurisdiction there. Namely, if a defendant in jurisdiction A inflicts harm in jurisdiction B, then jurisdiction B has jurisdiction over him. And it's the knowledge of where the effect will occur and the intent to cause that effect which supports the jurisdiction. So in other words, you have to prove, at least under US law, that the individual has the real intent of inflicting that harm in another jurisdiction. Well, I would argue that the Myanmar military has that inferred intent, at least at this point, because where else were the Rohingya supposed to escape to during the ethnic cleansing campaign but to Bangladesh? So to wrap up, I would just point out that the same argument that I've just presented for the Rohingya could also be made for the people of South Sudan who have been ethnically cleansed into massive refugee camps in Uganda, which is a state party. It could also be made with respect to Syria, which is not a state party, but has massively thrust refugees onto the territory of Jordan, which is a state party. But the Rohingya situation is the most blatant example, because I just think the intention is clearly inferred that these individuals, the Rohingya, were to be thrust onto Bangladesh territory, not somewhere else in Myanmar. So I close by saying that all of this obviously means a lot of diplomacy if it were to be activated. There has to be diplomacy with the Bangladesh government. There would have to be diplomacy perhaps with key state parties to the ICC. And that, of course, can be a very long haul because governments typically are not inclined to bring other governments into court this way. And Bangladesh itself, I think, would probably be hesitant to do so for political reasons. But I did want to set out for you where, from a lawyer's perspective, one could exercise jurisdiction, where I think there's hope for international justice for the Rohingya. So I'll close with that, Sarni.
Thank you so much, Ambassador David Scheffer. That's extremely well informed. Unfortunately, we do not have any more the minutes to open the floor. I'm really sorry, except that I need, David, I need to respond to your inferral of intent as ethnic cleansing, because like you have such enormous international voice in international law, and you made this intent as ethnic cleansing. As you know, your colleague Greg Stanton and others have used the argument that ethnic cleansing is actually an act of bleaching genocide. And when you said the Burmese military's intention was or is, to remove the population from the Burmese soil onto the Bangladeshi soil, you're making the assumption that the Burmese military knew for a fact that the Bangladeshi state actor would open the doors. But as military personnel and strategists would tell you, they would run through A to Z scenarios. And one of the scenarios would be that Bangladesh would not open the borders. And in that situation, we would be confronted with a mass starvation in the fashion of a Turkish genocide against the Armenian, where the Armenians were forced to march across the Kurdish and other desert, expecting that there will be perishing like flies. Only when the death rates were unsatisfactory to the young Turks did the Turks brought in mass executionary forces. And so I don't want you to go unchallenged on that one, but I am not allowing you to respond to me. I'm really sorry. So we'll talk again. Yeah.
Oh, I do so want to respond because I don't think we're in much disagreement at all.
Yeah.
I think it can be easily shown an inference of intent, to commit genocide. The question is what holds up for jurisdictional purposes to get it before a court. And of course, the Genocide Convention is the opening for the International Court of Justice. So I'm not diminishing that point at all, not at all.
Yeah. Okay. I apologize, everybody, because we are really late for the last session, and then Professor Spielberg has to go. Thank you so very much, and we will continue our conversation. Thank you for your effort.
Thank you.
Two journalists who are and this is a minor point in his presentation. I would have wanted him to hear this, but I just want to clarify the two journalists that are being held in Burma right now and that are being covered are Burmese. One is at least one is an ethnic Rakhine Buddhist. And so I raise that simply because my work has been to raise up the voices and the profile of those of us that are in the resistance, either in the diaspora or back in the country. And I think if you've been following closely, it's really disproportionately the Burmese, the local Burmese journalists that have been jailed, whereas I think foreign journalists do have a little bit more rope in their work and able to proceed. So I did just want to make that clarification so that their stories didn't get lost. Sorry about that, John.